Yes, Mr. King.
May it please the court, I appear on behalf of the appellant, Mr. Park. My learned friend, Mr. Harding, appears for CNH Industrial Capital, instructed by Gisby Harrison Solicitors. As the court will be aware, the appeal proceeds on 4 grounds, which can be found within the court bundle behind tab 1, albeit we don't need perhaps to turn to those at this stage.
Can I just do that, actually,
course.
if you don't mind?
Very good.
Which page is it in the PDF? Do you
It's
know?
in the PDF. It's page 13. They should be identical to the paper bundles.
They should be, but they very rarely are.
Indeed, I hope in this case
They
this
are
will be
in
an
this
exception.
case.
They are, you get a gold star.
Yes. Yeah, so he was wrong to infer or conclude that he failed to take into account relevant matters, took into account the litigant in person, ceded the generous right, well, yeah, I see, that's fine. Yeah, okay, thanks.
I'm grateful. And my lord, it may assist then actually to simply summarise in very brief form what the grounds are. I will speak in a moment, if I may, as to the structure that I propose to adopt today. But it's worth perhaps summarising it. If I paraphrase them, I hope I can do so in this way.
Yep.
The first ground, ground 1, page 13, is in essence Mr. Park's contention that there was insufficient basis for His Honour Judge Khan to decide that District Judge Woosnam was wrong in doing what he did, and the contention that the appeal ought not to have been allowed by His Honour Judge Khan. Grounds 2, 3 and 4 essentially mirror the 3 limbs that CNH pursued by way of CNH's application to strike out Mr. Park's rescission claim, and in effect they can be summarised as the new evidence discovered since trial, limb, the inconsistencies limb, and the causation limb, and in effect grounds 2, 3 and 4 seek to address those limbs in turn, because His Honour Judge Khan below accepted CNH's arguments in respect of each 3 of those limbs.
Yes.
Now, if I may, to signpost where I intend to go, subject of course to the court's views, my intention is, firstly, briefly, and I do mean briefly, to highlight a limited number of the salient points of the background.
Yeah.
Secondly, to highlight, again I hope briefly, the nature of the fraud alleged by Mr. Park. Thirdly, to talk very briefly about the interrelationship or otherwise between the 4 grounds of appeal. And then I propose to deal fairly fully with ground 2, because in my submission that will be where the meat of this appeal is likely to be. Then to turn briefly to grounds 3 and 4, and then to conclude briefly with ground 1. And again, I can explain in just a moment the rationale behind that, but in essence, ground 1 may fall away, subject to the court's determination of ground 2.
Well, if you're ahead on grounds 2, probably, but then 3 and 4, you may not need ground 1.
It would indeed.
Yep.
And conversely, and I accept at the outset that if there is an absolute bar to a rescission claim being brought unless there is new evidence in the sense of evidence that was discovered since trial, then it will be very difficult for me to maintain that District Judge Woosnam was entirely correct in the way that he approached matters, and ground 1 may fall away. Hence, in substance, my suggestion we deal with really grounds 2 first and grounds 2 most fully.
That seems most sensible.
I'm very grateful. Turning, if I may, then to the background, and I do intend to be brief, but I seek to highlight some points. I will take, if I may.
Just let my lady.
Sorry, forgive me.
I'm so sorry. I'm having all sorts of problems with my computer, and I'm not quite sure what's gone wrong.
Just let her sort it out, because otherwise she won't be listening. And
I think the only thing I can do is shut it down and listen, frankly, because it's locked itself and I can't unlock it. It's just frozen.
Is it?
It's completely frozen.
If you press the start button.
Yeah. This one.
Press start.
Yeah.
Right, and then press it to open it again. Do it again. Now try.
I do apologise.
Not at all, my lady.
The most infuriating thing.
It's a difficult machine, and my clerk forgot to bring a mouse, which makes life even more difficult.
I will confess,
I think the best thing to do, Mr. King, is just you carry on. I do, at least being partly a Luddite, still have a paper and pen.
I'm very grateful. I'm entirely in my lady's hands. I'm also fairly reliant on technology and anticipate I may have difficulties at some stage myself, but although I hope not. But I'm very grateful. That being the case, perhaps I can start by turning to the background. I propose to take much of the background.
Now, Mr. King, you've now got competition from outside.
Forgive me.
You've now got competition from outside, so can you keep your voice up?
Of course, apologies.
Yes, and we seem to have the noisiest court in the building here for some reason. Yep, keep going.
Grateful. I propose to take much of the background as read rather than rehearsing it.
Yeah, we've read most of it, but not everything. Anyway, speaking for myself.
Very grateful. Might I start with the paragraph 2 of my skeleton argument? It's the core bundle, tab 2.
We've got your skeleton separately.
Very grateful, and page 18 within both the paper and the electronic bundles. I set out a number of points at 2A through what should be E, although I see it as actually an erd in the numbering, like the lettering of it, but by way of core points in terms of the background. And rather than reading those, but propose to take the court simply to some of the documents very briefly to highlight certain points that in my submission are directly relevant to what this court needs to consider.
Second one's quite important.
My lord, yes, indeed. And indeed, that takes me perhaps neatly to the documents. And perhaps I can invite the court to turn to the supplementary bundle, tab 22. Should be page 247. And in fact, perhaps I might invite my lords and my ladies to turn to page 249. I'm afraid here the page numbers do differ from the electronic version. It would be page 67 in the PDF version of the supplemental bundle.
So,
page 249 in the paper version, which is sequential.
In the
supplemental bundle, indeed. In the PDF supplemental bundle, it will be page 67.
Ah. Right. Yep.
And the court will, I hope, see here one of the 4 hire purchase agreements that formed the basis of the, or at least a part of the basis of the underlying claim brought by CNH, within which CNH obtained the judgment which Mr. Park seeks to have set aside. Can I invite the court to note a couple of points? Firstly, towards the top of the page, there is the bold heading, the hirer, or the heading in a box, the hirer, and underneath it says limited company, name only, Park Hall Farms Ltd.
Yes. Is there any evidence about the reason for that mistake? Because it was called Park Hall Organics Limited, his company, wasn't it?
Park Organic Farms Limited, indeed. Yes, and I don't think there's any disagreement that Park Hall Farms Limited as an entity never existed.
And how did he get there?
Indeed. Well,
Well, we know from Mr. Smith that in his witness statement says that the documents were filled in. He doesn't say by him, or indeed by whom, but somebody on the CNH side before he handed them over to Mr. Park to get Mr. Park to sign them.
Indeed.
So somebody, we know not who,
Indeed.
on that side of the transaction put this information onto the document.
Yes, indeed, and there appears to be a conflict of evidence on that point. Mr. Park deals with it within his statement in response to the application to strike out. Now, that statement appears behind tab 19 in the supplemental bundle, and the relevant part is most likely to be paragraph 10, which is at page 231 in the paper copies, or page 49 in the PDF supplemental bundle.
Yeah, got that.
Very grateful. And in essence, Mr. Park says that, as indeed his pleadings state that as far as he's concerned, he was only presented with the final page of the documents. That, as to the third sentence of paragraph 10, that probably explains why the agreements refer to Park Hall Farms Limited. And he goes on to say, obviously I wouldn't have signed something that had this name on, as that wasn't the name of my company. So in effect, I think the answer to my Lord's question is that Mr. Park's evidence, at least, although there is a conflict, it seems, of evidence, is, as far as he's concerned, he had the final page, didn't appreciate what on his case would be the mistake on the part of CNH.
And they say it was all done
And they say it was all done, indeed.
appropriately. Yeah.
Indeed.
Okay.
Now, if I may briefly back to page 250, but back to the hire purchase agreement itself that we were looking at, page 250 within the supplemental bundle, which would be
68 or 67?
indeed, 68, I think, in the PDF. It's the second page of the document we were looking at a moment ago.
Yeah.
The simple point I seek to note is that about a third of the way down the page, it says hirer signature, signatures of hirer, and then position director. Now, I only highlight these points, of course, because, as we will see in just a moment, CNH's case must be that it was always intended that these agreements conferred a personal liability on Mr. Park. And of course, Mr. Park says, well, that's self-evidently not the case from both the reference to limited company, Park Hall Farms Limited, and indeed to a signature in a position as director.
And when was their case that it was always intended to be a personal agreement first made?
My Lord, I hope I can answer the question in this way. The deed of rectification seems to be the genesis of that assertion, and that is then squarely adopted within the claim brought by CNH.
Is it expressly pleaded in the particulars of claim in the first action that it was always intended to be a personal agreement?
I wonder if I'm not in any way ducking the question. I wonder if I might take the court to firstly to the deed of rectification and then to the particulars of claim. And the reason I say that being the particulars of claim refer back to the deed of rectification, which itself expressly adopts the analysis of mistake.
Yes, but the deed of rectification is, of course, signed by Mr. Park. I mean, I understand what you say about the circumstances of that. What I'm really asking is it your case that there was a clear, unequivocal falsity that cannot be denied in the particulars of claim in the first proceedings?
Yes, and that is because, perhaps I can take my lord to it, it is the particulars of claim in the what I'll call the first proceedings, the proceedings that give rise to the judgment.
Yes, it's 25, is it?
Indeed, tab 25, supplemental bundle, page 79 in the PDF, page 261
yes.
In the paper copy.
What I was struggling for was where is the allegation in these particulars of claim that you say is clearly false?
Yes, indeed. Paragraph 1C refers to the mistake.
Yeah, but doesn't say what the mistake was.
It doesn't, but it says the mistake was rectified by a deed of rectification. And 1A says that the claimant, i.e. CNH, entered into the hire purchase agreements. Forgive me, 1B makes reference to signing him purportedly as the director of Hall Farms Ltd. Now, that mistake can only be the mistake as to the contracting parties. There is no other mistake alleged by CNH.
Well, it's implied in there that the mistake was that he didn't sign in a personal capacity when he should have done. But it is only implied, it's not stated expressly. But if that wasn't the case, then the deed of rectification didn't correct the mistake, it achieved something else. So
Indeed.
It is there, perhaps.
Indeed. And Mr. Park's core point, which I will seek to stress today, is because this goes to the causation grounds, that, of course, if we have hire purchase agreements which name on the face of it Hall Farms Ltd and name a corporate entity rather than a person as the signatory, if there was, unless CNH can say that that was a mistake and that it was validly rectified by a deed of rectification, CNH can't bring the claim against Mr. Park because they only have a document that says the contract is with a corporate entity rather than with an individual.
So the falsity, which is not demonstrable because they still say that's a mistake, but you say it's not, is the word purportedly in B, because that gives you the clue to what my lord has described, the implicit allegation that it's the signing as a director.
Yes, I say it goes rather further than that. I entirely accept and agree with that proposition. The falsity is also the reference within 1C to the mistake.
Yeah.
I appreciate.
I mean, the identification of the mistake comes from the word purported.
Indeed.
Yeah.
And I should say, also for completeness, although I was proposing in just a moment, to take the court to the set-aside particulars, which plead this out a little more fully. But the falsity, I say, extends to the very fact that CNH come to court and say we are entitled to pursue Mr. Park. Because if Mr. Park is right, that there was never a mistake about the identity of the contracting party, and it was always intended to be a corporate liability rather than a personal liability.
Well, they couldn't pursue him under the hire agreements. If they'd actually got their tackle in order, they would have gone to court and got a rectification of the underlying hire agreements to reflect the situation that it was a corporate borrower, and they'd also have rectified the personal guarantee, which they took at the same time as the first of the hire agreements.
Yes, they might.
Now that personal guarantee at the moment isn't worth the paper that it's written on because it identifies as the hirer a non-existent company.
Indeed.
And believe me, although it's a very, very difficult document to read, I've been through it with a tooth comb. It doesn't have the type of independent indemnity clause that would have put Mr. Park on the hook, irrespective of that.
My lady, yes, indeed. And
which is what you say they recognised, because that was the impetus behind the email. They suddenly realised we've got 5 pieces of paper which we can't, at the moment, as they presently stand, give us a right of action. Indeed. So we produced the deed of rectification.
Indeed. I should also note for completeness that Mr. Park's pleaded case also is that again, as far as he's concerned, insofar as the personal guarantee is concerned, he was, in effect, tricked into signing that and thinks he saw only the final page of that, and it was explained as something different. I don't think we need to go there, because as my lady says, as it stands and absent any rectification claim, it is worthless, in my submission.
Well, on its face, I think you probably do need to go there with respect, because as pleaded, the case says that the mistake has been rectified by the deed of rectification. It doesn't identify the mistake. I take what my lord says about purportedly, but it says that the mistake was rectified by the deed, and therefore the deed is an integral part of the claim.
Indeed.
It said, right, well, now you can read these documents as referring to Mr. Park as the hirer personally, because of this deed.
Indeed. Perhaps I might then invite the court to turn to the deed of rectification itself, which is tab 24 in the supplemental bundle, electronic page 75, paper page 257.
Yes.
And if my lords and my lady have that, this is the document CNH rely upon as the deed of rectification. Again, I would invite the court to note, firstly, the naming of the parties. So we have CNH as party 1, we have John Andrew Park, a sole trader trading as Park Hall Farms, as party 2.
Is that true?
No. Mr. Park says.
He's never traded as Park Hall Farms.
No. Grateful to Mr. Park for confirming that behind me.
Right.
And what then follows is that there is identification of the 4 hire purchase agreements under background, and then at B, under background, that there is what I say is the operative false statement, namely that it was always the intention of the parties, and I interpose and say, of course, the parties mean CNH and Mr. Park personally as a sole trader, that the agreement should be concluded between them. And I risk labouring the point, but Mr. Park's point, of course, is that that must be false, and at the very least there is clearly a very strong basis for saying that is false, because CNH, as amongst other things a finance company, know full well that if they have a hire agreement that refers to a limited company and they put the name limited at the end of it and they ask somebody to sign as a director, that it's self-evidently not the case. That it was
and then take a personal guarantee from him.
But indeed, I'll seek to do so. Indeed.
And take a personal guarantee first.
Yes.
I mean, that's the killer for them.
Indeed.
Is that they took the personal guarantee and then enter into corporate hire agreements.
Indeed.
And then come back and say it was always intended that it should be personal, which obviously it wasn't.
Well, indeed.
So that's really what I was asking. That's really the answer to my first question.
Indeed.
Yeah.
Grateful. And perhaps I can, I will get to it in just a moment, but it will be my position for Mr. Park that there's never been any attempt substantively on the part of CNH to address that point And I will take the court to why I say that this is the case, and where, perhaps, if I may, in just a moment.
So you say they've never addressed the point of how it could possibly be, how B could possibly be true.
Well, I'm alive to the possibility of my learned friend correcting me in due course. What I will say...
You're entitled to correct you in due course, but you're entitled to tell us what your submissions are in the meantime.
Well, indeed. What my submissions will be, and I do intend to take the court through this fairly briefly, but what Mr. Park says is the fraud is pleaded out in my submission fairly carefully. I say that reservedly because I pleaded it, but it is pleaded out fairly carefully within the particulars of claim in the rescission claim, and I can perhaps
We're going to look at those.
Sorry, indeed. If we go there now, it is the core bundle, tab 14. It is the operative page is page 161, both electronically and in paper.
Yes.
There is, of course, the heading just above paragraph 16, referring to the judgment being obtained by fraud and or deceit perpetrated by the defendant. That is then particularised, and it's worth noting, particularly looking ahead to the causation grounds, the causation point that we will need to consider in due course. It's worth looking at how that is put. So the first point that is made is 17A, procuring the signature by misrepresenting the purpose of the reported deed of rectification. Now that refers back to what is pleaded at paragraph 8 of the particulars of claim, which is page 158. And it refers back to Mr. Smith, the CNH, having, Mr. Park says, told him that he was there to get the claimant to sign some paperwork to release the farm equipment, or words to that effect. Rather than, i.e. consciously misrepresenting the position about it being a release document rather than a deed of rectification that addresses the liability of Mr. Park personally rather than a company.
And that's the point on which there's a direct conflict of evidence, because Mr. Smith's version in his first witness statement is, I encountered Mr. Park in the yard, having climbed the lock gate, and explained to him chapter and verse that there'd been a mistake and that it was intended that he should be the hirer personally.
Indeed. Yes.
Which begs the question of why he would have signed it in those circumstances.
Well,
but that's a different matter.
Indeed. Yes, as my lady notes, there doesn't appear actually to be disagreement as to some of the circumstances, i.e. the point about this being Mr. Smith arriving late at night at about 10 p.m. or thereabouts, certainly in the evening, climbing over the gate. And of course Mr. Park says that itself seems inherently suspicious and is consistent with CNH in effect panicking, realising that their agreements are...
Mr. Park says he got him out of bed, as I recall.
Well, indeed.
Yeah.
Now, that was 17A. So part 1, procuring the claimant's signature by deliberately misrepresenting the purpose of it. And 17B really is another way of saying the same thing. CNH concealing the purported effect of the documentation and the intentions. 17C, issuing proceedings, i.e. what I will call the debt claim, the claim that CNH get judgment in, based on and predicated upon that deed of rectification, C1, and C2.
Well, it's C2 that's the critical allegation.
Indeed. Indeed, but of course, at the risk of labouring and repeating the point, the only reason CNH might refer within the particulars of the debt claim to the deed of rectification is to seek to import effectively the entitlement to have rectified those agreements on the basis that it was always the intention of the claimant and the defendant that there should be a personal liability. Now, so that in effect is the second point. It's the issuing of proceedings. And the third point.
But I mean, I'm sorry to labour this, but the critical foundation of deceit upon which you found yourself is that they have lied to the court in saying that it was their intention that it should always be a personal agreement, when quite plainly on any analysis they had taken a personal guarantee in order to underpin corporate agreements. And that is a fraud on the court.
Indeed.
It is putting forward to the court something that is false and fraudulent, and Mr. Park, as a litigant in person, is probably not best placed to identify that fraud.
Indeed.
Well, in fact, it might be very difficult. It seems to have taken until this morning for that to have been put like that. But the point is that they have defrauded the court.
Indeed.
By making false representations to it. And unless they can say, no, that was true, and it's impossible to me at the moment, I'll hear, of course, the argument against it, but it does seem to me difficult for them to say that they'd set up a process that was mistaken in the circumstances which pertained.
Indeed.
So, you know, that puts them in difficulty. But of course, they've still got all the arguments about how you didn't raise it earlier.
Indeed. Indeed.
Yeah.
And perhaps with it, can I briefly note then 17D, which is at the top of page 162.
I should tell you that happily my screen is unfrozen and I'm now able to follow everything you're saying online.
I'm very grateful.
Well, I was just about to say, having noticed that you hadn't got the papers, that we should rise, but I'm pleased that's the case. Good.
I'm very grateful. Hopefully my lady has page 162 within the...
Yes, I do.
Very grateful. And at the very top of that there is what is 17D within the particulars and the rescission or set aside claim. And these make the further points that the very act of seeking to obtain, and in fact obtain judgment, is, Mr. Park says, a fraud on the court, or deception of the court. And I labour that point because one of the points, one of the grounds, one of the points that His Honour Judge Khan held against Mr. Park was to say, well, the operative cause of the original defaults judgment being entered was the strikeout of Mr. Park's defence. Now,
speaking for myself, I don't need a lot of assistance from you on this point because even if you strike out somebody's defence to your cause of action, you've still got to prove your case. And if the essence of your case is based on a document which contains a false representation in it as to the state of affairs, i.e. there is a personal liability on the part of this defendant when there isn't, then it can't be said, oh, well, we struck out the defence, it's got nothing to do with it.
Well, indeed. It's for that very reason I was planning to be brief on that ground. But that's why I take the courts to the particulars of the alleged fraud, because, of course, in this case, because the defence of Mr. Park is struck out in the original action, the process of obtaining judgment is essentially an administrative one.
Yeah.
But, and I'm skipping ahead a little, but CNH still needs to write into the court and say we are entitled to judgment against Mr. Park. And if on Mr. Park's case they know that is not the case, because they know that it was always a corporate liability, not a personal one, they can't take that step.
It doesn't much matter because I don't. My impression was that wasn't quite how it happened in this case, because didn't the default judgment wasn't that entered on the first, what would otherwise have been the first day of the trial?
Yes, that is right.
Seems to have been rather a strange sequence of events in that the case was listed for trial notwithstanding that Mr. Park's default in failing to file a pre-trial checklist and his defence then gets struck out, he's refused relief from sanctions, but it gets listed for trial, and then the judge says, I can't deal with the trial today, and then what happens?
Yes, this is before my involvement. My understanding is that the trial, well, the trial is then adjourned.
Yeah.
I understand that's for what is then considered to be a lack of court time.
Yes.
And His Honour Judge Butler,
Yes.
who was due to hear the trial and who heard the application for relief, I think raised the question as to whether or not CNH wished simply to apply administratively for
The
judgment in
default
default. What that then takes us to, and it probably is worth looking at this stage, is the request made by CNH for judgment. And perhaps if I might invite the court to turn to that, because it's a page, it's at the very end of the supplemental bundle. It's tab 36, page 317, and electronic page 135 in the supplemental PDF.
Yes.
This is, we have the very letter that CNH writes, or Gisby Harrison for CNH writes to the court, dated the 25th of May 2017. I risk labouring the points. The third paragraph makes the point that in accordance with CPR 3.52, the request for judgment is made. The CNH don't believe, rightly, that it requires any hearing or judicial involvement, i.e. it is a purely administrative act. And then over the page at 318, we see the form that is attached to that and the certificate as to the background giving rise to that.
Yeah.
Now,
Well, he says, I certify the information above is correct.
indeed,
Does it certify the truth of the particulars of claim?
no, indeed. And lest that is a point that's taken against me, then...
That is taken against you.
Well, in case it is,
Yeah.
it may be.
Well, there's a statement of truth on the particulars, though, isn't there?
Well, indeed. And the very point I seek to make is the very act of writing into court saying we want judgment against Mr. Park for this sum must necessarily be predicated upon a contention that we are entitled to judgment on against Mr. Park. Which is why I take the court, of course, to 17D in the particulars of claim, because what Mr. Park says is part of the fraud is holding out to the court that CNH is entitled to that judgment when they must know, and I say CNH, I'm careful not to say Mr. Jackson, of course, because he is simply acting on instructions from CNH, but CNH must know that they are not entitled to that judgment, and therefore the very act of writing in and saying please enter judgment for 138,000 odd in itself is furtherance of the fraud and the deception of the court, which I can probably be very brief on the causation point, because in my submission that deals with the causation point, which we will get to later on perhaps, but as I say, very briefly. Now, can I simply note a couple of other points briefly at this stage? For completeness, might I invite the court to turn back to the particulars of claim in the rescission claim at tab 14 in the core bundle, and in particular to page 161, both electronically and in paper form. Forgive me, page 162.
Yeah.
I go there for completeness. We may not need to, but paragraph 19 deals with the personal guarantee point. And I mention this because at some stage it's been CNH's position, well, you know, that there was a personal guarantee in any event, and in part, and therefore the debt claim wasn't predicated solely upon the personal liability rather than a corporate liability.
I don't know much about the law of guarantees, if that's what their case is.
Well,
you have to have a primary obligor to be liable under a guarantee.
Right.
It's a secondary liability, unless it's an indemnity, which this one isn't.
Well, indeed, and I hope that point is made, albeit much less eloquently, at 19D,
Yeah.
which makes the point that no entity exists and no enforceable obligation can exist. But it also makes the point, which I raised for completeness at 19A, that Mr. Park has no recollection of signing the agreement, though he does recall Mr. Smith presenting him documentation which was incomplete. Which again, yes, there's a conflict of evidence again, it seems, on that point. But again, it is squarely dealt with within the particulars for the set-aside claim, the rescission claim. Now, whilst we are there, having noted what paragraphs 17 and 19 say, can I then invite the court to turn to CNH's defence to the set-aside claim, and in particular, sorry, I should say it's the core bundle, tab 15. And page 170.
I'm right, aren't I, that 2B, which is the allegation that the fraud has no reasonable prospect of success, was not part of the judgment below?
Indeed.
Do you want to go to 170?
Sorry, forgive me. Page 170, I take the court here because paragraph 34 responds to paragraphs 16 to 18, and therefore including paragraph 17 as to the particulars of the alleged fraud, and then paragraph 35 responds to paragraph 19, i.e. to the points about the personal guarantee. Yeah. Now, I note in fairness to CNH, paragraph 34 refers back to the reasons set out above, but in my submission, none of those reasons provide or attempt to provide an answer to the always the intention point, which is why I say substantively CNH haven't, despite it being carefully pleaded in paragraph 17, substantively responded to that, other than to say that Mr. Park signed it and it was explained to him, in effect. But they don't address the, in my submission, inherent and obvious implausibility of that point, given the personal guarantee, given the naming of the corporate entity.
They say something slightly odd, to me at least it seems a little odd, in paragraph 19 on page 168, 19C, about the recital that my Lord the Master of the Rolls pointed out earlier. They say that it doesn't matter whether that was true or not.
Yes, and if that is what that means, then in my submission that can't be right. Indeed.
Well, I suppose the only point that can be made against you is that the deed of rectification recites that what obviously was not the intention was the intention, and if Mr. Park had freely entered into that document, making himself liable, knowing that he was recording something that was not correct but was now agreed between them, it might be valid.
Indeed.
But I mean, that is a long way down the road at a trial.
Exactly that, my lord. It is clearly a triable issue. I couldn't say probably on behalf of Mr. Park that he would be entitled to the strikeout or summary dismissal of that claim on that basis himself, because there is a tribal issue. But of course, that's what founds Mr. Park's core submission, that there clearly is a strong case in fraud.
Yes, well.
This court isn't required, of course, to determine it,
Yeah.
nor was His Honour Judge Khan, nor District Judge Woosnam. But of course, there will be part of my submission that was precisely why, well, one of the reasons why District Judge Woosnam was exactly right to do what he did, which is to say this is a matter that needs to go forward to trial so those points can be determined. Now, I think that deals substantively with the background. It's safe to note very briefly a couple of points, if I may. Can I invite the court to note the nature of the defence Mr. Park entered to the original debt proceeding?
Yes.
It's a supplemental bundle, tab 26, and page 277 in paper, page 95 in the electronic supplemental bundle.
277, did you say?
Indeed, forgive me.
Thank you.
This is, I'm afraid it's not the best copy, but I hope it's sufficiently legible. This is the defence that Mr. Park files in response to the debt claim. There is reference over the page. We needn't go there to matters relating to damage of the equipment whilst in CNH's possession. That matters not for today's purposes. But the core point I invite the courts to note is really the first 4 lines, the first 5 lines of that defence, and in particular reference to what Mr. Park says, the debt is to Hall Farms Ltd, open brackets, and not John Andrew Park, as per the finance agreements. Now, I labour the last point, because again, this foreshadows perhaps one of the grounds, which is allegations of inconsistencies. And of course, CNH say, well, Mr. Park says that the debt was to Hall Farms Ltd, and now in the rescission claim says that any debt was actually Park Organic Farms Ltd. And CNH says, well, there's inconsistency there, and
what he's saying is the debt's to a company and not to me personally. Indeed. So he's denying that he has any personal liability under these agreements, and he's reflecting what's on the face of the agreements themselves, which names the hirer as Hall Farms Ltd.
Indeed, but my lady has the very 2 points I was going to make.
Why?
And again, it is for that reason that I propose to be brief on the inconsistency point, because again, the risk.
It's entirely consistent with the case that he's running throughout.
Indeed, it's not a personal liability; it's a corporate liability,
and it names Hall Farms Ltd as the hirer.
Indeed.
I mean, the one thing it doesn't say is that if it had named my company correctly, it would have said Park Organic Farms Ltd.
Indeed, indeed. And I do say, as my lady points out, that as per the finance agreements is important. Because, again, on Mr. Park's case, of course, that is part that is populated by, well, it's common ground, in fact, that's populated by CNH. There's perhaps a disagreement as to precisely when it's populated, but that's common ground that CNH populate that part. And so when Mr. Park enters his defence, he says, well, the debt being to a corporate entity, it is to Hall Farms Ltd because that's the company named on the finance agreement.
Well, they also, I note, got the name of they got the registered company number wrong as well, but I think that was only in the guarantee.
Indeed.
They put in the company name of the registered number of a company which does exist but is in Oswestry.
Indeed. And this was a point, again perhaps foreshadowing the inconsistencies grounds. that District Judge Woosnam made reference to when first considering matters, which is, well, that there may be questions to be put at trial of the fraud allegation to Mr. Parks to say, well, why did you write Hall Farms Ltd on the defence? But equally, one would expect there to be questions of CNH.
What he wrote on the defence was absolutely 100% accurate. The debt is to Hall Farms Ltd as per the finance agreement, and not to me. That's correct. It's not even arguably wrong.
Yes.
As per the finance agreements. Now, he doesn't say that's not my company, that was whatever, but he does say that which is accurate. He then says, I don't remember signing the indemnity, fine. Wasn't explained to me if I did, fine. And then he goes on about other things.
Indeed. Now, in fairness to CNH, and so as to deal with it at this stage, the point is made, I think, by CNH that in the particulars of the set-aside claim, Mr. Park says that when he was signing the agreements, he was intending to sign it in his capacity as Director of Park Organic Farms Ltd.
Where's that?
It's the, forgive me, I will find the reference, it's the particulars in the rescission claim. It will be tab 14.
Tab 14, isn't it?
Indeed.
Paragraph 6.
Yeah.
I'm very grateful.
Page 157.
Indeed.
7.
So what?
Well, quite. But I raise that because CNH's case, as I understand it, on the inconsistency point is to say, well, in the defence, Mr. Park says Hall Farms Ltd, and in the particulars of claim and the rescission action, he says he was acting in his capacity as Director of Park Organic Farms Ltd.
Still can't see the inconsistency myself. I mean, what he says in his defence is the named hirer is Hall Farms Ltd, but as my lord says, he doesn't go on to say, and that's not my company.
Indeed.
In his set-aside claim, he says, actually, my intention was to sign as director of my company because I carry on business through my company, and that was the hirer.
Well, indeed, and we probably dealt then with ground 4, because that is the very point that Mr. Park urges and urged upon Judge Khan, to say, well, one, there is no inconsistency, but two, if there is, it's certainly not abusive for the reasons canvassed. The only other 2 points I'll make briefly in terms of background, if I may, is firstly the obvious point, but important point, that there was, of course, no positive or express pleading of fraud within Mr. Park's handwritten defence to the original debt claim.
He doesn't actually say anything about the rectification process or deed at all.
Indeed. No, indeed.
He appears not to have appreciated
Indeed.
that it mattered, or indeed to have known anything about it, really.
My lord, yes, indeed. Now, of course, that point might be in part for me and might be in part against me, because, of course, part of CNH's case as well, he should have raised those points. But of course, the point I make is that, of course, in terms of delineating the issues before the court previously, it is in fact common ground that there was no allegation of fraud in the original proceedings, as must be the case.
So that puts us squarely into TACAR territory and not into ELU territory.
Yes, indeed. Quite, and indeed, again, foreshadowing perhaps the meat of ground 2, although there potentially is a arguable distinction in principle between TACAR territory and that in the current case, in my submission it will be extremely fine.
And the only distinction is that there's a default judgment. Because a fortiori, if you can't say it's an abusive process because you could, with reasonable diligence, have pleaded before the first time round and you get a judgment on the merits. If you don't even get as far as a judgment on the merits and you've got a default judgment, then you could say that you're in a stronger position still, or at least an equivalent position.
Indeed. Now, the other point that might be said is that, by way of distinction, again, perhaps this is skipping ahead to ground 2, but I'll make it now in cases of assistance at this stage, is that potentially there's a distinction in terms of knowledge, because in the Takar case, in essence, if one reads Mr. Justice Linden's analysis in the Elu case of the decision of the Supreme Court in Takar, then a distinction is drawn between questions of knowledge and it might be said that in Takar, Mrs. Takar didn't know at the time of the original trial that she hadn't signed the profit-sharing agreement.
She didn't remember, like Mr. Park, she didn't remember whether she'd signed it or not. She strongly suspected there was something iffy about it.
Indeed.
She wanted to explore that further, and because of the stage at which she raised the point, she was debarred from doing so, and she wasn't able to get the expert evidence. After the event, having gone to trial and actually been disbelieved on this point by His Honour Judge Pearl, she gets one of the foremost handwriting experts in the country to prove that it was a genuine signature, but it had been translated from another document onto the document on which the other side were relying. And that was the end of that. But, well, we'll see what Mr. Harding has to say, but I can't see there's a distinction in the type of situation between that and saying, well, I don't remember what I signed. I know I only signed the last page, and I certainly didn't have it explained to me that it was a deed of rectification, which would have made me personally liable, because I wouldn't have signed that in any event. But we never got to the stage where I was able to raise that defence.
Indeed, and again, at the risk of taking matters out of order, just to develop that a little at this stage, it might be said that the difference is that Mr. Park knows more than Mrs. Takar knew. It's an incredibly fine distinction, if that is the distinction, and I was going to raise this point later, but perhaps I'll raise it now since it arises. One only has to postulate, of course, as my lady notes, in Takar, of course, Mrs. Takar did indeed seek permission to rely upon handwriting evidence ahead of the original trial. That permission was refused in part because of the lateness of the stage at which the application was made. And in effect, the Supreme Court say, because there is no reasonable diligence requirement, then because Mrs. Takar didn't have at least full knowledge, absent the handwriting expert as to whether she had signed the document or not, she should be allowed to proceed, and that should proceed to a trial of the fraud issue in that case. Now, one only has to take that a little further to see how fine the distinction is. Because let's say, and this is not, I think, suggested, but let's say Mrs. Takar had applied for permission for a handwriting expert, but, in connection with the application, had in fact obtained a report, even in draft, and let's say that report had said what we know the report subsequently did say, which is it's not your signature. Oh, sorry, it is your signature, but it's been transposed. Then she would have full knowledge ahead of the trial, and all the knowledge she subsequently had. And therefore, in effect, what CNH's case must boil down to is to say, well, there's a distinction between Takar and the current scenario. But in effect, Mrs. Takar ought to be in a better position because she may not have, and probably didn't have, a handwriting report ahead of trial, and therefore didn't have the knowledge. And therefore, the absence of a reasonable diligence requirement saves her. But there is a complete bar to Mr. Park bringing his claim in the current proceedings. And that, in practice, is going to be my submission on grounds 2. I will take the court through briefly the various judgments referred to, but in essence, my overarching submission is going to be that if what His Honour Judge Khan concluded is right, then we are left with a frankly bizarre and unsupportable distinction between, for example, Mrs. Takkar's case and Mr. Park's case, despite the narrowest of distinctions in terms of the background.
Or putting it another way, he doesn't apply the ratio in Takkar properly.
Well, indeed. Finally, if I may, by way of background, it's probably a minor point, but I raise it again for completeness. The court will, I suspect, be familiar with what I will call the fate of Mr. Park's defence in the original debt claim, namely that it was struck out specifically for non-compliance with an unless order in respect of the filing of pre-trial checklists. Now, I can take the court to the documentation if need be, but the simple point I make, which the court will have seen in the documents, is that Mr. Park's position, of course, was that the unless order itself, the actual order, was received by him after the date for compliance had passed. And in fact, we can see both Mr. Park says that, but also we can see why that may well be the case, because actually helpfully, CNH within their defence note the chronology. The unless order itself was dated the 29th of March 2017, and the date for compliance was the 5th of April 2017, so a very short time period.
The only problem with all of that, of course, is that these are points that he made in trying to get relief from sanctions, and sadly for him, they cut no mustard with the courts, and he's exhausted his remedies in relation to that.
Yes, absolutely. I don't seek to go behind that in any way. But if we get to a stage where this court were to conclude that His Honour Judge Khan was wrong and the appeal to be allowed, but were also to conclude that District Judge Woosnam was wrong, and that this court were therefore required to substitute, most likely, this court's own judgment on the application, then of course, without in any way seeking to go behind the points my lady raises, which is, yes, absolutely, there were two applications for relief from sanctions. They both failed and they were dismissed. Nonetheless, it forms a part of the background, particularly when one considers the reliance that His Honour Judge Khan, amongst others, placed on the decision of Mr. Justice Linden in the Elu case, which was a case characterised by what was described as disgraceful behaviour on the part of whether...
well, Elu's different because whether it's right or wrong, Elu is a different scenario because the fraud claim was fought out, and then the party decided that it wanted another bite of the cherry by raising some fresh evidence to support its fraud case. So factually, it's not a Takkar case, and it falls within all of the obiter dicta, whatever they mean. But that is not this case. Elu is very different. But as I understand it, District Judge Woosnam wasn't too bothered about the fact that Mr. Park didn't get relief from sanctions. He had just allowed the case to proceed to trial. Yes,
of course, it's worth noting District Judge Woosnam's determination, of course, preceded the judgment of Mr. Justice Linden in Elu.
Yes.
And therefore he didn't.
He didn't have it, but
have that judgment.
It post-dated Takkar, which he applied methodically.
Indeed. And of course, as much for the interest of the court as anything else, of course, CNH's original application to strike out post-dated this court's judgment in Takkar, but predated, of course, the judgment in the Supreme Court in Takkar. Hence, amongst other things, the original response saying the reply to the defence and the set-aside claim saying, well, if the court's going to consider this, please at least wait for the Supreme Court's decision in Takkar.
Yeah.
So we find ourselves, of course, really very much in the middle of this developing area, perhaps, of jurisprudence. That I think deals with the salient points by way of background, unless the the court has any other points in that respect before I move on. Very grateful. I was going to then seek to deal with why I propose to deal with ground 2 next, but I think it will be fairly obvious from the
That's just
exchanges
the
thus
meat
far.
of this, really, isn't it? So.
Indeed. And to turning then, if I may, to ground 2, and again, if helpful, the ground itself appears, forgive me while I turn it up, but it appears in the core bundle behind tab 1, and it is page, at the very bottom of page 13, the very top of page 14. But if I may, I can really paraphrase it in this way. His Honour Judge Khan decided, in my submission, that there was a precondition, a necessary precondition, that there was, that a rescission claim required both new evidence and new evidence in the sense of evidence of facts and matters discovered since trial as a necessary precondition for bringing a set-aside claim. And what I invite the court, what I hope to take the court through, is my submissions as to why the authorities don't set down such a precondition, but that was rather a development in my submission of His Honour Judge Khan. If I'm wrong about that, and if to some limited degree they do, they're not of general application and don't impose such a requirement in the present case. And thirdly, if I'm wrong about both of those, and if in particular the decision of Mr. Justice Linden in Elu does set down a general principle to that effect, then in my submission I say respectfully, Mr. Justice Linden was wrong to do so. Now, it's helpful and important in my submission to look at what Judge Khan, what His Honour Judge Khan decided, and I propose to take a little longer. I really hope I will not labour these points, but what I propose to do is to look firstly at what His Honour Judge Khan decided on, in effect, the grounds 2 points, so as to see that he considered the new evidence discovered since trial to be a precondition, and then to look at precisely why His Honour Judge Khan decided that, and we'll see that there are 4 passages in previous authorities that he appears to have had regard to, and then to take the court to fairly briefly to each of those 4 passages, in large part so that I'm not being unfair to His Honour Judge Khan in selectively taking the court only to some of those.
Well, we've read the judgments. So
very, very grateful.
You can take it in that way.
Very grateful. Now, in terms of what His Honour Judge Khan decided, the judgment, of course, is behind tab 7 in the core bundle. And might I invite the court to turn to page 82 within the core bundle, which takes us to paragraph 75 and following. Really 74 and following of His Honour Judge Khan's judgment. Now, this perhaps takes matters slightly backwards. There are 2 things in my submission that His Honour Judge Khan decides are necessary preconditions, the discovered since trial point, as I'll put it, and the new evidence point. And in fact, they come in reverse order, because paragraph 74, the final line of that paragraph, His Honour Judge Khan notes that in District Judge Woosnam concluding that the evidence was nevertheless new because it had not been before the court, he was wrong to reach that conclusion. And that is then developed in paragraph 75 by His Honour Judge Khan saying that issue is binary. It's either new or it's not. And then at paragraph 76, over the page 83, that takes us to His Honour Judge Khan's rejection of my submission below that a claim to set aside judgment on grounds of fraud can be brought even if the evidence is not new, despite the absence of the words precondition or prerequisite. And within paragraph 75, forgive me, I'm taking us back, His Honour Judge Khan refers to new or not being a binary question, and in the second sentence says evidence previously known to a party is not rendered new because it has not been subject to scrutiny during the proceedings or by the court of trial. Now, I take the court to those passages because in my submission it is clear that what His Honour Judge Khan is saying is that new evidence in the sense of discovered since trial is a precondition for a set-aside action. And that must, in my submission, follow from His Honour Judge Khan's judgment, because he rejects the submission that a claim can be brought if the evidence is not new, and he rejects the submission that evidence that had not been before the court could count as new. And that, I say, is important because in my respectful submission, His Honour Judge Khan was wrong to do that, and that vitiates his judgment.
If he was right about it, Takar would have been decided differently.
Well, indeed. Indeed.
Because at least some of the evidence was before the court. So
Indeed.
The line.
Well, indeed, as my lady noted previously, the court had to consider whether Judge Pearl, Queen's Counsel, if I recall correctly, believed Mrs. Takar and said actually he believed the other side anyway.
Yeah.
Indeed. Now, I may risk labouring the point, and I will signpost this and can probably go a little faster than I perhaps intended to. What we will see from His Honour Judge Khan's judgment is that His Honour Judge Khan refers back to 4 sources, it seems, from which he derives that requirement. I should say, I may refer today to necessary preconditions. That's probably tautological, because something is a precondition by definition is necessary, but I hope the court will forgive me if I err in that respect. His Honour Judge Khan appears to derive this conclusion from 4 places. One is paragraph 153 of the judgment of Mr. Justice Linden in the Elu case. I'll simply signpost these at this stage and then we can go to them in just a moment. The second is paragraph 65 of Takar in part of the speech of Lord Sumption. The third is paragraph 56 of Takar in part of the speech of Lord Kerr.
Which is just Highland, isn't it? It's just the Royal Bank of Scotland.
Yes, absolutely,
yeah.
Indeed. And the fourth is part of the decision of Justice Handley in the New South Wales case of Tubia, which we will see because Mr. Justice Linden also refers back to that same part. Now I say that because I hope, in fairness to His Honour Judge Khan, I will take the court to the 4 areas or 4 parts of the authorities from which His Honour Judge Khan deduces what he considers to be that requirement. I propose to go to each in turn, but I will be fairly brief given the court's familiarity with matters. But it's helpful in my submission to look at TACR first and then to look at ELU. So if one takes firstly paragraph 56 of TACR, which is part of the speech of Lord Kerr, that is found in the authorities bundle.
Page 129.
Very grateful. And as my Lord notes, indeed all that is, I don't mean that pejoratively in any way, that is simply reflection of paragraph 106 of the Royal Bank of Scotland and the Highland case. If one wanted to look at it in the Royal Bank of Scotland context, it's tab 2, page 50, but we can stay in TACR, I think, for the moment. It's probably as easy to do so. So that I'll turn to it myself. Now, page 129, what one sees, the portion of the judgment of Lord Justice Aikins in the Royal Bank of Scotland case, and I won't read it, but I paraphrase. That judgment refers to there being, in effect, three principles. One might actually say it's two, but the second has two parts to it, but nothing turns on that. The first, of course, is conscious and deliberate dishonesty. The second is what I would call materiality, and that is the second line down at 477A over the page 130. And then the third appears just above C at 477C. Thirdly, the question of materiality of the fresh evidence is to be assessed by reference to the impact on the evidence supporting the original decision, not by reference to the impact on what decision might be made if the claim were to be retried. That's why I say it might be two principles. It might be, you might well say it's conscious and deliberate dishonesty, materiality, and the materiality is broken down into two parts. It matters not, I think. There are three principles enumerated within that judgment. Now, I'd invite this court to note a number of points briefly. Firstly, they are, of course, referred to as principles, and that may well, in my submission, be important because they are principles which might guide the court in carrying out a broad merits-based consideration of questions of abuse, rather than on the face of it being preconditions for that. Secondly, which I note really for completeness more than anything else, that they are principles agreed, of course, by counsel in that case. Now, it is right to say, as we see it, paragraph 57 below, amongst others, Lord Kerr says in his speech, I agree these are the relevant principles to be applied. So I don't take that point too far, but it's apt to note the genesis of these as being matters agreed by counsel in that case and then adopted. And I say that really because without undermining the principles, one does need to be perhaps a little careful if one is treating those as effectively statute or black letter law and placing too much reliance on particular words within that. But more importantly, thirdly, we see here, not in any meaningful sense, a precondition of new evidence discovered since trial, but rather a principle of materiality. And that, in my submission, is very important, because we are dealing here with what will come to be described as safeguards against the vexatious use of subsequent proceedings alleging fraud, and the safeguard that the second principle and perhaps the third principle seek to address is that of materiality, i.e., would this have made a difference? Can it be shown, as we see at 477B, that the fresh evidence would have entirely changed the way in which the first court approached and came to its decision.
Well, the answer is all dependent on how they got their judgment, and they got their judgment by a statement of truth in relation to a false claim.
Indeed.
Full stop.
Right. And by requesting judgment when they knew they weren't entitled to do so.
Yeah.
Indeed. And really that's the answer, I think, to ground 2, because what we will see in my submission, His Honour Judge Khan takes from the judgment in Elu a precondition to say, well, one can't bring a set-aside claim unless there has been new evidence in the sense of discovered since trial. That, in my submission, is a development of what Mr. Justice Linden says or doesn't say in Elu.
Well, Mr. Justice Linden is not binding on us, but the Supreme Court is.
Indeed.
And the Supreme Court has made it very clear that there is not a requirement.
Quite.
That there is new evidence in this situation.
Yes, I will develop that just a little. I think one can say clearly that the Supreme Court has said there isn't a requirement of new evidence discovered since trial, because
exactly.
What we will see is Lord Sumption does say, and I say this I hope conspicuously fairly, that there is a well-established proposition. I will come to this in just a minute, but there is a well-established proposition that an action to set aside a civil judgment must be based on new evidence not before the court in the earlier proceedings.
Yes, but the conclusion that Lord Kerr reaches at 54 is that it is not right that a judgment may only be set aside where the party who makes the application can demonstrate that the fraud could not have been uncovered with reasonable diligence in advance of obtaining the judgment.
Yes, indeed. Indeed. Now, Mr. Justice Linden, again, seeking to assist the court, because I recognise this is an area of perhaps developing jurisprudence, Mr. Justice Linden seeks to draw a distinction, perhaps, between, on the one hand, the reasonable diligence in terms of acquiring knowledge, as in Mrs. Tackar's case, and reasonable care, if you like, or diligence in the prosecution of proceedings. Now, again, it will be my submission that... Sorry, forgive me, my lady.
Angels on a pinhead,
well,
my observation to that. I mean, we can see why Mr. Justice Linden said what he did, because his case was a somewhat different case where they'd already run the argument once, and it was a double bite at the cherry case. And one can well see that one would exercise much more caution where it's 2 bites of the cherry in that sort of case than in a case like this where there's not even been a single bite.
Yes.
But a matter of principle, I mean, I don't know how far we need to go into Elu because it deals with a very, very different scenario from this.
Well, perhaps I will be fairly brief then, because my lady has the very points I seek to put before this court. Now, the other point that I will seek to make from the principles derived from the Royal Bank of Scotland case, whilst we're here, is that, again, consistent with that, that those principles assume, rather than require, evidence that is assumed, the evidence that is adduced after the first judgment has been given. And again, I say that's important. When one sees that at 477A, the fourth line down, material means that the fresh evidence that is adduced after the first judgment. It doesn't say, of course, there must be fresh evidence that is adduced after the first judgment. It's still less that must be discovered after the first judgment. It assumes that that will be the case.
I think, Mr. King, we may have to need to speed up a bit.
Of course.
I think we need to give Mr. Harding a reasonable opportunity to deal with his approach. And I mean, I think we have the points on Takkar and maybe Elu. I'm not, make the points quickly, touch on them, but we've had your written skeleton, we have the points on these cases. and certainly Mr. Harding needs to be on his feet really before lunch.
Of course, I'm very grateful. But perhaps then, my lord, I might simply provide some simple references, lest they prove helpful. I think the court has my point about what Lord Kerr says in his speech in Takar. There's then paragraph 65, which is part of the speech of Lord Sumption, the Takar decision. Subject to the court's view, I don't propose to take the court necessarily to these then, but rather to simply provide some references in the interest of speed that can be checked by the court if need be. But it is paragraph 65, which is tab 4, page 132, where what one sees, part of the speech of Lord Sumption, where he suggests or decides that new evidence not before, the proposition that an action to set aside a civil judgment must be based on new evidence not before the court in the earlier proceedings is a well-established proposition. And of course, the point I make is that that is conspicuously not a requirement for new evidence discovered since trial. It is specifically new evidence not before the court. Then, moving on from that, can I simply signpost this point, and perhaps we needn't delve into it in greater detail. Part, of course, of what the Supreme Court in Takar has to decide is what the restrictions on an action to set aside on grounds of fraud are, and what protection there is against either an influx of those or vexatious litigation, or whether there ought to be, amongst other things, a reasonable diligence requirement. And again, my lords and my lady will no doubt have the point. It's worth signposting a couple of points, but I don't propose to take the courts to them in the interest of time. Paragraph 67, Lord Kerr in his speech recognises the risk, but goes on to say, I do not think that the imposition of further conditions beyond the three principles we've seen in the RBS and Highland case would be consistent with the long-standing policy of equity of reversing transactions procured by fraud. And Lord Sumption, in his speech at paragraph 62, page 131, notes the flexibility of the abuse doctrine post Arnold and National Westminster Bank and Johnson and Gore Wood, and in paragraph 36 rejects, well, perhaps I will take the court very briefly to paragraph 63, forgive me, not 36, which is at page 131. And it is at 478F and following, where Lord Sumption, clearly having seen in draft Lord Briggs's speech, says he cannot accept Lord Briggs's more moderate variant of the defendant's argument. The reason is that proceedings of this kind are abusive only where the point is at issue and the evidence deployed in support of it not only could have been raised in the earlier proceedings, but should have been by the flexible.
That's critical here, isn't it? Really? It's critical because of the procedural nature of the way the case came to be struck out. You can't say against. You can say that he didn't raise it in his original defence, but he didn't say anything about the rectification deed, as my lord pointed out.
Indeed.
And so it's very hard to say he should have raised it, and if he had, it would have still been struck out, and we'd still be where we are now. So, you know.
Yes.
I think that, following on from what my lord says, if you look at Lord Sumption and the whole thrust of his judgment in this case, last line of paragraph 63, it follows that unless he deliberately decided not to investigate a specific suspected fraud or rely on a known one.
Indeed.
Well, that presupposes that he's got all the information available. And what Lord Sumption is saying is that unless it can be shown that he deliberately decided he wasn't going to rely on a known fraud, it's not an abusive process. Well, that's pretty strong.
Indeed. Well, absolutely. And that is why I do take the court to this, because in my submission, Lord Sumption says, and indeed Lord Kerr says, they both say, of course, forming the majority judgments of the Supreme Court, that in effect, one has a flexible abuse doctrine that must not be constrained by those sorts of preconditions, save for the ones noted. And of course, Lord Kerr says specifically in paragraph 67, yes, the principles, which he, in fairness he described as conditions, set out in RBS and Highland, combined with the professional duties of counsel, are sufficient, but the imposition of further conditions wouldn't be consistent with that. And that, I say, is the answer to this.
So actually, the majority is Lord Sumption, because
Indeed.
He disagrees with Lord Kerr on that point, and therefore Lord Sumption has it, because the other three agreed with both of them. And therefore they must have quite odd. They must have disagreed with Lord Kerr, having said they agreed with him on the point that Lord Sumption distinguishes Lord Kerr.
Well, if he does, and
I've never seen that before. I haven't noticed it.
But my lord may well be right. In practice, I say that Lord Sumption and Lord Kerr, in their speeches, say really substantively the same thing.
Well, except that he says he disagrees with Lord Kerr. That's the only little wrinkle on that point. I mean, we needn't spend time on it. But he says, I can't accept. It's on this basis that Briggs suggests a less absolute rule than that proposed by Kerr. I can't accept either the defendant's argument or Lord Briggs. Oh, I see. Okay.
Yes, it's the defendant's argument, it's not Lord Kerr who's disagreeing with.
It's okay. It's okay. Anyway, either way, it's pretty clear what he's saying.
The majority view, anyway, you say supports you.
Absolutely.
However you count it up.
And it's worth noting my Lord's point, which is a very helpful one, which is Lord Sumption disagrees with Lord Briggs. Lord Briggs says, if one follows through in his speech...
well, Lord Briggs is that on a limb, basically, because he doesn't agree with anybody, thinks it should be much more flexible, gives some policy reasons for doing that, and then says, but that doesn't apply to default judgments anyway, so I don't think we're going to derive a lot of help from Lord Briggs with respect.
No, so can I simply note this? What is interesting is that is what Lord Briggs' speech, paragraph 69, which is page 134, notes. Because in my submission, what Lord Briggs recognises was precisely what the import of what Lord Sumption and Lord Kerr were saying, which is this leaves open a lot of possible challenges on grounds of fraud. Lord Briggs recognises that Lord Kerr proposes a clear rule. The judgment may always be set aside unless either of those two conditions, fraud was actually alleged in the earlier proceedings, or there's a deliberate decision not to investigate. And
the emphasis is on the word may.
Yes, indeed. Quite. Because of course the court always has the power to restrain.
I think we're getting a little bound up in an analysis of this very interesting Supreme Court case.
Perhaps to return to our case, the strongest that the finance company could say about what happened in the first action may be paragraph 7 of his witness statement, which he wasn't allowed to use, which is on page 40 of the supplemental bundle, as to what he was consciously trying to do in the first action and why he wasn't able to do it. It seems to be in paragraph 7 in his statement of March 2016. He sets out what is the nub of his current claim.
Yes, indeed.
And he wasn't allowed to do because it was served late.
Yes.
his application for relief from sanctions failed.
Indeed.
And that might be the high watermark of the finance company's case against you, perhaps.
It might indeed, and of course the obvious but important point is, but by virtue of the fact that relief was not granted and Mr. Park was not entitled to rely upon it at a trial, and of course there was no trial, this wasn't before the court.
Yes, quite.
Which takes us squarely into the territory of the speech of Lord Sumption
Yes.
in my submission in TACAR. I'm grateful. The only other point I briefly flag, and I will do so incredibly briefly, is that, again, Lady Arden in TACAR notes, and I needn't even provide references perhaps, but, notes the illogicality or the logical difficulties of automatically imposing a sanction by way of a ban on bringing a rescission claim that may be wholly disproportionate to a lack of diligence, but that's paragraph 98. Notes in paragraph 102 that there is, as of now, at least no procedural rule about any restriction on a person bringing a rescission action, but notes that it's a matter for the Rules Committee if they wish to look at that further. And notes, and again I say this for completeness, at paragraph 104, that the statements of principles, the three principles in the RBS case, deal with the position at the trial of a rescission action, not with the threshold conditions for bringing such an action. That being said, may I then move on and briefly deal with Mr. Justice Linden's judgment in Elu and what Mr. Justice Linden says about the Tubia case, but I will be brief.
Yes.
Grateful. I won't labour the points because they've been canvassed before this court already, including by my lady this morning. The context is important, of course, for Elu. That there was a disgraceful lack of engagement by the defendant in that case, as found. There was, in paragraph 181, is the reference in Elu if needed, a deliberate decision not to comply with directions taken for tactical reasons. And as my lady notes, Mr. Justice Linden noted that what Florweld were seeking to do in that case was to have, having taken that deliberate decision, a second bite of the cherry. And that was because, of course, there was a full and fully contested trial in that case.
Well, he could have dealt with it very simply on the basis that it fell within one of the exceptions that was recognised by the Supreme Court in TACAR.
Indeed.
Instead of going on at great length about whether there was some separate principle about fresh evidence, but anyway, he chose the course that he did.
Well, indeed, and on my reading of Mr. Justice Linden's judgment, he does, on my reading, decide that it falls within the res judicata principle because there has been a trial and these issues have been addressed, and therefore, actually, as my lady says, doesn't need actually to go on to consider other matters.
So it's basically a Henderson and Henderson case, and that Lord Kerr has envisaged that you might get a Henderson and Henderson case where it's been canvassed previously.
Indeed. And again, just to encapsulate that point neatly, what we know that the issues of truthfulness and authenticity of the claimant's evidence were decided, and what Mr. Justice Linden does say, of course, is that well, there was a case to answer, but it has been answered because there's been a trial on those points. And if it helps, the reference to that is paragraph 190, 4417E, page 192. Now, where that leaves us, again I say this as briefly as I can, is this. The key paragraph that His Honour Judge Khan places reliance on within the Elu decision is paragraph 153. and that's page 181 behind tab 5 in the authorities bundle.
Yep.
And I won't read it out, but I'd invite the court simply to note what is said there between D and E on that page. And it is from this that His Honour Judge Khan considers himself to be bound, or at least to be persuasively indicated, to impose the precondition that he does. I make a couple of points as briefly as possible. There's reference to a key ingredient in the cause of action. Well, what one could argue for some time as to what precisely is meant by key ingredient, we probably don't need to. But the key ingredient is that the party and the court were deceived by the fraudulent evidence of the other party. The key ingredient is not in itself, even on Mr. Justice Linden's analysis, fresh or new evidence discovered since trial. Now, Mr. Justice Linden does go on, of course, at the 5th line of that paragraph to say, the facts or evidence relied upon must be materials which were not known at the time of the trial, to the party now alleging that it was deceived. That doesn't help CNH in this case in the way that CNH has suggested it does, and it shouldn't have caused, in my submission, His Honour Judge Khan to impose the precondition that he did. And I say that, firstly because, of course, the key ingredient, whatever status one affords to that, is deception of the party and the court. Well, in this case, on Mr. Park's case, we have deception. He was deceived by having a document put before him, told it was something else, and being asked to sign an incomplete document. We have deception of the court because, again, as has been well canvassed this morning, the court is deceived because CNH say we're entitled to pursue him personally and rely upon the always intended point. So we have those. Insofar as one goes further and takes the 5th line onwards to impose a further precondition of new facts or evidence not known at the time of trial, then I say incredibly briefly 3 things. Firstly, that is not part of the key ingredient of the cause of action. Secondly, it is a function of the background in the LU case, and in particular the disgraceful behaviour of the second bite of the cherry point, the conscious decision on the part of Florweld to not comply and then to seek to have a second bite of the cherry. And thirdly, if it does seek to set down a general precondition of discovered since trial, then
it's contrary to everything that Lord Sumption said.
Exactly. Now, finally, the point
which
I make.
The judge himself acknowledges at para 155.
Well, indeed. And finally, the point I make on that is one can see that this takes us briefly onto the to be a point. I hope I pronounced that correctly. But we see at paragraph 153, little 1, that Mr. Justice Linden, in reaching that view, cites, amongst other things, paragraph 15 of the judgment of Justice Handley in the to be a case. Again, that was referred to by Lord Kerr, and in essence, what Lord Kerr in Takar, of course, and the point that seems to be drawn from that is to say, as we see it, 4406F, that a representee who knows or discovers the truth in time is not deceived, and such knowledge is a good answer to any action based on the misrepresentation. Well, again, that reflects the background in both Elu and indeed Tubia, where there is a trial, and the matters are ventilated at trial, albeit perhaps with incomplete evidence. And that represents the important distinction, because of course where there has been a trial, either a party has deployed all the evidence it has and lost on that basis, or a party has chosen not to deploy all the evidence. And on the first of those, if a party has deployed all the evidence that a party has and has lost a trial, then necessarily, of course, there needs to be fresh evidence discovered since trial, because otherwise you're simply rerunning the first trial on the same evidence. That, of course, is different where there hasn't been a trial. And on the second of those points, if a party has the evidence but chooses not to deploy it, well, that takes us directly back to one of the possible exceptions considered by the Supreme Court in Takar. I will endeavour to conclude ground 2, and actually really to conclude much of what I say thereafter very quickly. Can I simply signpost two further things in terms of ground 2 before moving on? Firstly, can I invite the court briefly to have regard to what I will call the fraud unravels all point, made by the Supreme Court in a number of places in the Takar decision. Again, in the interest of time, I won't take the court to every instance. Lord Kerr refers to it at paragraph 43, page 126. We needn't go there. Lord Briggs refers to it being a well-established principle. Again, we needn't go there, but it's paragraph 68 at page 133. It is, I think, helpful to look briefly at what Lady Arden says, which is...
Can we not do that? We've looked at it. I don't think we need to go and see that.
I will simply say that the point I seem to take from it is paragraph 92, and Lady Arden says, it's only right that in the generality of cases, a judgment obtained by the fraud of the winning party should be rescinded, because it's wrong in principle that the person proved to be a fraudster should obtain and retain the fruits of his fraud. And that takes us back to the point that I won't dwell on now, I was going to raise, but about the distinctions, or the very fine distinctions between Mr. Park's position and that of Mrs. Takar. That deals, I think, with ground 2, and I insist on that. Ground 3 and ground 4, inconsistencies and causation.
You've already addressed us on those.
Well, I think I probably have. I'm conscious of time. The court has my skeleton. I don't propose to address the court further on ground 3 unless there are particular points that the court would wish to hear from me from. Ground 4, in terms of causation, again, the court has, I think, my core point, which is CNH can't validly do any of what it needs to do to get this judgment if Mr. Park is right about the fraud. Now, the only point I will make briefly is that if one looks through, amongst other things, what Takar, but also all the other authorities say, the authorities are consistent about the need for the fraud to be an operative cause. His Honour, Judge Khan, appears to say in his judgment, well, the operative cause is the striking out of the defence and therefore the judgment in default off the back of it. That, in my submission, is a wrong test. My learned friend says...
He's wrong.
Well, indeed. And my learned friend says, well, His Honour Judge Khan decided that was the only, on a proper construction, I hope I'm not misphrasing, decides that was the only cause, or the only operative cause, and therefore was entitled to do so. That can't, I say respectfully, be right, because for the obvious points, but CNH can't write into the court and request judgment if Mr. Park is right about the fraud. They can't bring the claim in the first place, and so on and so forth. And I think that deals with ground 4, again, unless I can assist the court on those points.
No, thank you very much.
Could I very briefly just say in 2 sentences where I say that takes us from ground 1?
Yes.
Because, again, I won't develop this beyond my skeleton because the points are made in there. But in essence, His Honour Judge Khan says, I am entitled at an appellate level to interfere with, or at least read aside the abuse question because District Judge Woosnam either didn't refer to or didn't consider certain points. Now, for the reasons set out in my skeleton, which I won't develop in the interest of time, what His Honour Judge Khan does in my submission is to take the absence of specific reference to particular points and to infer from that they weren't considered by Judge Woosnam. The only exception to that is that His Honour Judge Khan says that District Judge Woosnam was wrong in law to decide that evidence not discovered since trial effectively was sufficient. And that is why I say it follows on from ground 2, because in practice, if this court is with me, and that is not a precondition, then District Judge Woosnam was not wrong. And actually the simple disposal of the matter then is that I invite this court to allow the appeal, but actually to restore Judge Woosnam's judgment. Of course, if I'm wrong about that, and both judges below were wrong, then it falls to this court, but this court will have the reasons as to why I say this is clearly not abusive in the way that the court considers Mrs. Takar's set-aside claim to be clearly on the non-abusive side. I have whizzed through grounds 3, 4 and 1, but I hope that will suffice. Can I assist further at any points at this stage?
No, thank you very much.
Very
keen. Thank you. Mr. Hardy. My lords, my lady.
I propose to approach my submissions in broadly the same order as my learned friend, but of course I'll be guided by the court as to what is most useful to hear from first, and I'll take it in order as it comes. If I can start, as my learned friend did, with questions about the background, it won't surprise the court perhaps to hear that I seek to put a different complexion on the factual background than my learned friend does, and on the documents in particular. If we start with the finance documents, the guarantee, and the deed of rectification. The point that has been made before by Mr. Park and has been ventilated further today is to say, well, how can the documents have come to be in that form if the original intention was that there was going to be a finance agreement between the finance company and Mr. Park personally? And a point is taken about the timing of the personal guarantee in that connection. And perhaps that is the place that I would start, because on the timing point, there are 4 different hire purchase agreements entered into at different stages. 2 of them are entered into later in March 2014. One is June 2013, and the next one after that is November 2013. In terms of timing, the first finance agreement, which we'll find at page 248 in the supplementary bundle, but which is page 66 in your PDF version thereof, has as its date of signing by Mr. Park the 4th of June 2013. And that is also the same date on which the personal guarantee is signed, which we find at page 255 or page 73 of the PDF of the supplemental bundle. So in terms of timing, the sequence that we have is a personal guarantee and a hire purchase agreement signed by Mr. Park on the same date, so the personal guarantee not being given prior. And there is then a succession of hire purchase agreements which have the same features as the first hire purchase agreement in terms of referring to Park Hall Farms Ltd. Now, the point that is made is, well, why would you have a finance agreement and a personal guarantee if the original intention was that the agreement was going to be with Mr. Park in his personal capacity, be it trading as Park Hall Farms or in some other way. And CNH's case about that has been to affirm that that was the original intention and there was a mistake that was made. But that mistake has never been fully ventilated in evidence or been the subject of disclosure.
There's no evidence from your side whatsoever to explain why they took the guarantee. None that I can find.
That's correct, my lady. Yes, that issue has not been ventilated in evidence.
However, the evidence that there is from Mr. Smith is that he understood when he went to get Mr. Park to sign the documents the first time round was that there was a need for an all monies guarantee because there was going to be a corporate hirer.
Yes, that was what was communicated to him from within CNH.
Right, so how does that square with there being an intention throughout that it should be Mr. Park personally?
That squares with it on the basis of there having been a mistake about how the documents are produced and how the arrangements are implemented. If it is right, and...
What does that mean?
I say, I'm conscious that this is not something this is in evidence, so I'm saying this as a way that these documents could be in that form without it being as...
What is a way?
Without explanation.
What is a way that the documents can be in that form when you intend to have a personal agreement between Mr. Park and the company?
If the original intention was to contract with Mr. Park in his personal capacity, so suppose he goes along and sees some equipment he wants and says, I want to buy that, and I want to buy it myself. If a mistake then happens in the way that that is carried through in the administrative systems of the finance company, so somewhere in an entry, somebody writes down a limited company instead of Mr. Park himself, it could then follow that the documents will be produced, completed with information referring to a limited company, rather than to Mr. Park.
Seems a bit far-fetched to me, in circumstances where it's known to all the parties that Mr. Park is operating his business through a limited company, and the person who is deployed as the agent for the signature of the documents is labouring under that apprehension, and could easily have disabused the finance company of that mistake if he read the documents himself.
I don't know that it is in evidence that everybody involved knew that Mr. Park was operating his business through a limited company. And that may be the essence.
Why did the finance company write down the name of a limited company? Mr. Park didn't type that name himself.
No,
Mr. Park doesn't seem to do typing.
They even went to the trouble of getting the registered number of the company. It's not as if they just put the name down wrongly. They actually looked up the company's name, obviously on the company's register, and wrote down the name of the wrong company.
Now, I want you to be very careful about this. I want to know what the company's submission is. I've written, because it's the only way at the present I can understand it, it could be that the documents were infelicitously drawn. Is that right?
My lord, yes, I don't put it any higher than that because, to be clear, I am putting forward a general explanation of how the documents could be in that form without saying this is actually CNH's cases about precisely what did happen.
It could be, but you must accept that it's vanishingly unlikely.
Well, my lord, I would submit that if, given the nature of the processes that finance companies often operate, if one does have a mistake back at the root of it all, that can well lead to documents being produced in relatively standard forms which reflect that mistake. And I say that as a...
I mean, I don't get it really because of my lady's point. I mean, if we go to this document, we've got to live in the real world, Mr. Harding, not in some world where we don't understand how finance companies operate and how farmers operate. In the real world, they have filled in this entire piece of information, Park Hall Farms Ltd, with the address of Park Hall Farm, the equipment, everything is filled in type, written. My lady said she saw the company number, so she'll tell me.
That's in the guarantee, not in the underlying.
Guarantee, and it's typed, is it?
Yeah.
Yeah. So how does that happen if the intention of the company was to deal with Mr. Park? How do you take a guarantee? If the intention is to deal with Mr. Park, you don't need a guarantee. Surely a finance company knows what a guarantee is.
Well, that's certainly correct. If you are contracting with an individual, you don't need a guarantee. But if you've got a mistake in the way that the application has been recorded or processed, which means
that doesn't mean anything, Mr. Harding. That is not an answer to my question. My question is, the finance company runs a business where it's in the business of taking personal guarantees when it contracts with companies. And it knows jolly well that it only needs a personal guarantee if it is contracting with a company. How can it be mistaken about contracting with a company when it types the name and number of the company into the documentation? It is, frankly, nonsense, isn't it?
Well, my lord, the information that goes into the hire purchase agreements must reflect something that was in the records at CNH. And if those records have got a mistake in them because it was supposed to be Mr. Park, but somebody wrongly has put in a limited company name rather than Mr. Park trading as Park Hall Farms, that mistake can then be pervasive. It can go into the hire purchase agreements. It can go into...
Whose mistake is it? Where's the evidence of the mistake?
Well, my lord, as I say, I'm putting this forward as an explanation for how this could have happened.
It's a totally, with respect, implausible explanation. And when you read it against the background of an email which says, oh, whoops, we're not going to be able to enforce any of these documents against anybody, because, bother, we've put a non-existent company in as the hirer. It's blindingly obvious that what's happened is, instead of expending the money on going off to court to get rectification, to put the right company name in, they've decided to cut corners and pretend that in fact it was an agreement with Mr. Park all along. And speaking for myself, it's the only way I can read this sequence of documentation. And the absence of any direct evidence from your clients with an explanation of the so-called mistake reinforces that view.
Well, my lady, there is the evidence from Mr. Smith of his encounter with Mr. Park, where he did explain what the
yes, but in the very same witness statement, he says, it was my understanding, Mr. Smith's understanding, that it was going to be a corporate guarantee. A corporate hire with a personal guarantee, he says at the beginning of his witness statement.
Yes, that reflects the information that he was provided with, which appears in turn to reflect the mistake that is mentioned in the particulars of claim.
But he's the dealer for the machinery maker, so he's the person who's selling the tractor. And he's the person who's in possession of information about Mr. Park and his business. He says, well, Mr. Park wants a tractor. So he passes information up the line to CNH. And it's his view at the very start of all of this that it's going to be a corporate hirer with a personal guarantee. I mean, surely, if it had always been the intention that it was going to be Mr. Park, that would have been reflected in the documentation with which he was provided in the first place. And he would have said, oh, I thought I was disabused of that notion when I went off to get it signed.
Well, my lady, Mr. Smith's evidence doesn't go into the detail of what if any, involvement he had beforehand and what knowledge he had about
and there is no other evidence about what, if any, involvement anybody else at CNH had beforehand either. Or an explanation of the email.
Well, my lady, that's correct. The information before the court is limited because the issue of alleged fraud has never been tried and hasn't been the subject of disclosure or witness evidence.
But it has been the subject of the pleaded defence, and the pleaded defence to the claim for rescission is it was always our intention that it should be a claim against Mr. Park.
Yes, the pleaded defence to the rescission claim maintained the position referred to in the recitals to the deed. And agreed with Mr. Park that the documents wrongly referred to Blackpool Farms Ltd, stating that they should refer to Mr. Park instead.
Well, he doesn't agree with that.
No, exactly. I think Mr. Park's allegation is the agreements referred to the wrong hirer, and CNH agree that they referred to the wrong hirer, but disagree about who the right hirer should have been.
Anyway, your submission is that there could be an innocent explanation for all of this.
There could be, and the matter of fraud has not been tried, and there may well be material about it. So,
but we have to assume for present purposes that there is at least an arguable case, if not a strong arguable case, of fraud. Correct?
Yes, there was no application to strike out the allegation of fraud on its merits, and in terms of the relevance of the merits of the allegation, for the purposes of considering whether the action to set aside the judgment proceeds, ordinarily the strength or otherwise of the fraud argument isn't a determining factor as I read the authorities, but it is potentially relevant, I accept, on the second part of the case, which is whether the action is nonetheless an abusive process, even if it appears to satisfy the requirements of the principle set out in the Highland Financial Partners case. In that situation, I accept the court is entitled to take into account the view it forms of the substantive allegations.
Is entitled to take what into account?
It's entitled to take into account, in the broad merits-based assessment, whether the second claim is an abusive process, of the nature of the allegations and what view the court has formed of those allegations and the material there is, but of course without trying those issues. Because of course the court's consideration of an application to strike out on that more general abuse basis would be very different if there was an entirely flimsy allegation for which didn't stand up on its own than if there is one which the court thinks has some merit. But
I mean, I can understand there's a tribal issue as to whether or not Mr. Smith came along at 10 o'clock at night and explained all this in full meticulous detail and said, look, it's terrible, Mr. Park, we're in terrible trouble, all this documentation drawn up by a terrible mistake that we made, and we'd like you now to take personal responsibility for everything, and that's what this deed does. And Mr. Park said, of course, Mr. Smith, I'm delighted to do that and to rectify your mistake for you and get you off the hook. Of course there's a tribal issue as to that. At the moment I can't see there's really a tribal issue as to whether or not you deceived the court when you applied for judgment.
Well, my lord, we say that there is a tribal issue about that because...
Well, whether you deceived the court or not?
Yes.
Yeah. Okay. Why?
Because on the basis of the that submission would depend on effectively the absence of an explanation for why the documents come to be in the form that they do. So in particular, it would have to be said that the allegation that Mr. Park makes that the judgment was obtained by fraud is unanswerable because the allegation in the particulars of claim in the original proceedings that the defendant was personally liable because he signed a deed of rectification which stated that references to Hall Farms Ltd would be treated as references to him. The application would have to be made on the basis that Mr. Park's allegation that allegation in the original particular claim was a deliberate lie was unanswerable. And in my submission, that's not the position. The position as set out in the original particulars.
Well, it's not the position that it was a deliberate lie, that there was an original mistake, notwithstanding the the company's own documentation, A, that it put in the company names, the company number, the company everything else, it got a personal guarantee, and it said, whoops, we haven't got any liability here, we better get this deed of rectification.
Yes.
That doesn't to you make it look like a deliberate lie to suggest that the original thing was a mistake?
No, in my submission there is at the very least a tribal issue about that, because the particulars of claim is based to that extent on the deed of rectification. The deed of rectification is a document that Mr. Park has signed.
But it's not based on it on an estoppel basis or anything of that kind. It's based on the deed of rectification reflecting what was the intention of the parties at the very outset, a common intention, not just the intention of your clients, but a common intention that Mr. Park should be personally on the hook for hiring the machinery, irrespective of the fact that the guarantee was taken from him. That's the way in which it's pleaded.
Yes, and I don't say that CNH wouldn't have to rely on Mr. Park's signing of the deed of rectification on an estoppel basis. The response would be, the claim has been put forward on the basis of the deed. The deed is a document that Mr. Park has signed, and on the information CNH had in those proceedings and the evidence they had from Mr. Smith, that document was taken to Mr. Park and explained to him, and he signed it nonetheless. Therefore, CNH is entitled to rely on that document as properly recording what the position was. Now,
it may be entitled to do that, but my point is it may not be entitled to say what is at least incredibly unlikely to be rebuttable, namely that there was not an original mistake made by your client. Mr. Park may have made lots of mistakes, I can see that, but your client is saying your client made a mistake. And I find that very hard to believe, and I find it faintly unpalatable, to be quite honest with you, Mr. Harding, that that's being pursued in the Court of Appeal, in this court. I find it unpalatable, because it cannot be right. Just plainly in common sense terms. We don't, we're not dealing here in technical legalities. We're dealing with a finance company who's putting a case which is completely, obviously nonsense. I mean, that's what's happening. I'm afraid I don't have scales or rose-coloured spectacles here.
Well, my lord, I don't invite you to put such spectacles on, or
well, I think you are. You're expecting me to live in an unreal world, and I can tell you I don't.
My lord, what I would say is the detail of the mistake and what may have happened on CNH's part has not been fully explored.
No, it hasn't, but the documents are there.
And
there's no explanation put forward.
You would have
and you've got a judgment on the basis of having said something that looks to me to be plainly false.
And moreover, just to add to what my lord has said, I take the point that this would all be for exploration at trial. That's a perfectly fair point, fairly put. But you would have expected, at the very least, if the pleaded case was, well, it was always intended to be with Mr. Park from the word go, and there's not been any attempt to mislead the court in that regard, that some evidence would have been put in from the hire company at the stage when you were seeking to strike out his case as an abusive process. And there isn't any. That's what I find quite telling, is the fact that a decision has obviously been taken to try and strike him out on, rightly or wrongly, on the technicality.
Well, my lady, the application, because of the grounds on which it was put, did not need to address the merits of the fraud allegation or the way in which the claim was originally put. And the basis on which...
with respect, it did need to address the question. You run a causation point, which depends upon it being said that the fraud was not the operative cause, to which the answer that's put forward by Mr. Park is yes, it was, because you needed to allege that there was a mistake when there wasn't one, and yet there's no evidence about that.
Well, my lady, that point, in effect, from Mr. Park's perspective, is a pleading point. because he says that you couldn't get to judgment without having pleaded those matters. And that is what that particular part of the causation issue turns on. It doesn't turn on the merits of whether or not the allegation in the particulars of claim was false or not. It's premised on Mr. Park's case that the allegation was false, and that's what caused the judgment.
It might be a little surprising that there was evidence on the merits, actually, from the finance company before judgment was entered. Judgment was entered in July 2017, and there's a witness statement from Mr. Smith, which is dated February 17, which is at PDF page 33 of the supplemental appeal bundle. And I think it's the only, apart from Mr. Jackson, that's listed as evidence, it's the only evidence from the finance company that there is. And it strongly supports the proposition that there was no mistake. And the finance company has never troubled to explain why that might be.
Well, my lord, this is that is one of the statements that was served in the earlier proceedings.
Yes.
I believe there were 2, possibly 3 other statements as well. And so what is in this bundle is only the witness statement of Ian Smith, because that was the one that seemed to be most immediately relevant.
So is there a witness statement somewhere which says that there was a mistake?
I cannot say what those other witness statements did say. I don't recall the detail of them sufficiently.
Because it would be supported by a statement of truth, wouldn't it, if there were?
Those witness statements would have been verified in the ordinary way before service.
So I think my lord is referring to paragraphs 11 and 12 of Mr. Smith's witness statement, which says, filed on behalf of your company, the transaction was introduced in the name of a limited company to be supported by Mr. Park's personal guarantee. I took with me unsigned and undated finance agreement which had the finance details already completed and standard form of personal guarantee. I told him on the phone in advance that a personal guarantee would be required for the finance agreement. And then we have a statement of truth on behalf of your company signed by a solicitor, which seems to be, as I say, false. And I think you're aware that that's an offence. So it is very serious, actually, what we're looking at here, Mr. Harding. You're saying this is all, something that we can just wave aside. But what I quite understand the tribal issue about what happened when the gate was climbed over and what was said by Mr. Park to Mr. Smith and vice versa. That, plainly, we cannot say anything about. As you understand, I am extremely concerned about the foundation of the original claim.
Yes.
And I think some serious consideration by CNH needs to be given to what they think they're doing. If they're going to suggest to the court that that should be upheld and is not, and is in any way a safe foundation for a judgment of some very large sum of money against Mr. Park.
Yes, my lord.
That's what's happening here. Well, maybe we break early, and you maybe can take some instructions as to how you're going to put your case, that this should not be set aside, or this should not be the subject of a fraud action.
Yes, my lord.
Good. We'll resume at 2 o'clock.